Welcome back. You'll see and hear now some analysis on the application by former President Jacob Zuma and the French arms company Thales for a permanent stay of application, an application for a permanent stay of prosecution in the charges against them. You'll know that they're both accused of corruption. Advocate Makhosana Mbonami is a legal expert. She's in our Durban studios now. She's been in court in Pietermaritzburg for much of the day. Advocate Mbonami, good evening to you. Thank you very much indeed for coming in tonight. We're all aware of how long this litigation has gone on for. We're talking about things that happened in the 1990s. The various legal charges first were brought up against Zuma in 2005. The judges now have to decide who's responsible for the delays. What factors for you are going to be important in their making this decision?
Thank you for having me. The courts use a three-step test in determining whether or not to grant an order for a permanent stay of prosecution. The first consideration is whether or not there was prejudice suffered by the accused, and you take into account all the irregularities, whether there is unfairness, whether the unfairness is perceived or whether there is actual unfairness. Also, all the factors that have been coming into play, such as the procedural irrationality mentioned by CAT SC. The second consideration that the court has to take into consideration is the nature of the case. It is a public interest. There's public interest, and it is in the interest of justice whether or not to continue to trial. And the final consideration is whether or not it was a systematic delay. That is to say that it was out of the state's hands whether or not to continue with the prosecution. So the court has to balance both the rights of the accused as well as the interest of justice. That is the test they use to determine whether or not to grant the order. So we heard arguments for both counsel for the accused, and today we heard from the state. The state started out explaining the chronology of the events and the decisions by the NPA, from that of Nguga, Pikoli, that of Mshe, and finally that of Abrams. And that at every turn, the decisions made, save for that of Mshe, were lawful, and that the heads of the NPA were within their rights to make that to make those decisions. And that although it was later found that the decision of Mshe was wrongful, it doesn't take away from the fact that it is in the interest of justice to continue to trial, and that there was no actual harm or prejudice on the part of the accused because they participated in the litigation up to now, and that you have to consider that there were several interlocutory applications. Finally, it wrapped up by saying that the court should not look into assigning blameworthiness, but to look at the case in a broader context. And it comes down to balancing the rights of the accused and interests of justice, and their submission was that this application should be dismissed with cause.
Advocate, I mean, one of the big issues here, we all know about the Zuma spy tapes, the recordings that showed that the former head of the NPA, Bolelani Nguka, and he had left this position, that he was interfering with the timing of the decision to prosecute Zuma back in 2007. It was the time of the ANC's Polokwane conference. Are you expecting this to be one of the crucial issues then? This will be the claim, in a way, that Zuma's advocates will be resting on, that this shows some sort of malpractice or some sort of misconduct in the prosecution?
Well, the submissions of counsel for the former president are that it was the NPA's head, and therefore falls on the NPA as an institution indiscretion that led to the wrongful decision, which contributed to the delay. Today we heard the state saying that while the decision was wrongful, and while the decision was later found to be irrational, we cannot assign only to the NPA the blameworthiness in that. And that the issue of the spy tapes is while in the grand scheme of the case may be relevant, it is not relevant for the purposes of this application, because the considerations are as I've already elaborated before. So the submission of the state is one, there was an application to strike out, and there was a consent order, which means that both parties agreed that the material read out and submitted by counsel for the former president centered around those spy tapes considerations. The court should not consider them when making its decision. So since there was an agreement that it would be struck out, it means that the court, when making its decision, must take that point out of the equation.
Talking of striking out, I mean, one of the claims that was made by Zuma's legal team at first was that an advocate in the case, Advocate Billy Downer, he prosecuted Shabir Sheikh. They said that Downer was motivated by hatred of Zuma. As I understand it, that's now been struck out. What does that mean? Does that mean they no longer believe the claim that they were making?
An application to strike out means that there is a part of evidence, because this is an application, all the evidence is set out in affidavits. An application to strike out means that a portion of the evidence that is submitted to the court for the court to consider in making its decision is now going to be set aside, and that when the court decides on the matter, it must be as though it was never before it. So that's the meaning of striking out. In this case, we know that they took a consent order to strike out that material. It just means that they have considered it, and they realize that for the purposes of this application, it is not necessary and it is not relevant.
One of the key people in this case is a man called Elaine Tetard, and he wrote what looked like an agreement. It's been claimed to be an agreement around a bribe. That's what the state says. He seems to have disappeared. As I understand it, Thales says he can't be found. There are some claims that he might even have passed on. I mean, if this were a movie, this would be a key moment in the movie. It seems quite bizarre that this key witness could actually have sort of, I suppose the right word is, disappeared in this way.
Yes, when that submission was made, and then when it was dealt with by the state today, it spoke to the issue of the fact that the application is based on that they will not be able to have a fair trial because a key witness is missing. That means that they will not be able to plead or answer or defend themselves. And that for the reason that the delays have led to the unfairness, and that the unfairness means they will not have a fair trial. And their submission in that is that at this point, because of these delays, they must not have to stand trial, and that blame should be placed on the state.
Advocate Makhosana Mbonami, thank you very much.